G'day there guys, it's your Aussie Hubby Markee coming to you live and police monitored from an undisclosed location. Back at it again with another episode of r/LegalAdvice. Now I know you love these ones, so sit down, relax, chuck another prawn on the barbie, and get ready for some bloody good content. Our first post today is by user HouseThief2322, titled, Colorado, what do I do with my house? Just like leave the keys on the counter? Like many Americans, I lost my job in 2008 and couldn't afford my mortgage. I had a friend in a similar situation and he just stopped trying and said he'd move out when he got evicted. I didn't feel I had much of a choice, so I did the same thing. I was out of work for 15 months and never made a single payment during that time. During this time I got several notices of late payment, notices of pending eviction, and then nothing. It never happened. 12 years later, I'm still here, and I haven't made a single mortgage payment. As you can imagine, during this time, I also fell behind on my property taxes. Eventually, I was able to pay off the delinquent taxes, and I've continued to pay them on time every year since. To be honest, I'm not even sure who owns my house anymore. No one has even mailed me anything about it. I looked it up on the county records, and I'm still listed as the owner. Now to my question. Frankly, the house is too big for me now, and I'd like to downsize. My kids have moved out, and my wife passed in 2016. I just don't need this house. The county thinks I own it. How do I tell them I don't, and I've just been living here rent-free? Ironically, I'm worried if I leave, no one will pay the property taxes, and then I'll have a new problem to deal with. Thanks. If the county thinks you own it, then you likely do. Adding on here that OP may have the same mistaken impression a lot of people do. Having a mortgage does not mean the bank owns your home. The bank has a claim on the home if the borrower fails to pay, but they have to go to court and foreclose on the loan to gain ownership of the property, which, as you say, would be recorded. What housing could you procure that would be less than your property taxes? Leaving is problematic. You're still the owner of the house and will be responsible for what happens there. Code violations, taxes, etc. Any chance it's worth more than the odd lien at this point? Call a title company local to you and see if they are able to identify any liens and get you a payoff. Don't give them any information about the old loan. See what they can find on their own. I don't think I could find any house cheaper than what I'm paying now. It's true. It's just the house is too big for me and getting harder for me to maintain. Plus, now that my kids are gone, it's pretty lonely here. I'm not sure what this house is worth. I bought it for $250,000 and had the mortgage down to about $200,000 before I stopped paying, and I haven't paid anything since. A house in the neighborhood sold for about $450,000 a few months ago, and two more are for sale at $475,000 and $525,000, though mine is smaller and not as nice. Like I said, it's becoming hard to maintain, but I have been keeping up. I put a new roof on 6 years ago and redid the kitchen and the master bath to modernize it. Not the HGTV special though, no barn doors here. It's probably worth a decent amount, but like I said, I haven't paid a dime on the mortgage in years. I like your idea of calling a title company and seeing if they can find out for me. Thanks. Definitely talk to a real estate attorney. Depending on your loan, the interest accrual, and what state your house is in, you could possibly have a home with a good chunk more than what you owe the bank. Practically, a maid that comes twice a week will still likely be less than new rent, property taxes. Loneliness is a different issue though. Maybe think about renting a bedroom or two. You can take your time and find some good tenants, especially if you charge below market rents, which you can afford to do. This would give you a little bit of a social outlet, plus some extra income. Maybe find someone who can help with yard work, etc., in exchange for reduced rent. The loan agreements are likely gone. Whatever your balance was back at the time of the foreclosure is probably still your balance. It's your house. Whatever you find out from your title company, you're free to call a realtor and sell it. Sounds like you'll pocket $250,000 on top of having a free place to live for a dozen years. Nice transaction. Compound interest on a 15-year-old loan will be significant, so I'd suggest the balance could be a lot more than $200,000. However, perhaps the act of foreclosure effectively cancels the loan. Before leaving your home, be sure to get your finances together. If you've had trouble just paying the property taxes over the last few years, let alone with a mortgage, then I think I can safely conclude that you've had some money problems. Hopefully things are better for you now. If not, you might want to think twice about leaving. Any place you move will have rent or mortgage payments unless you get enough money from the sale of this house to buy another entirely in cash. Make sure you account for all the costs of the new place so you don't end up over your head financially. Let's take a different look. You purchased the house, your name is on the deed. You signed the loan. 12 years ago, when everything went downhill, you stopped paying the mortgage, but you have paid the property taxes. The bank filed a lien and defaults, but stopped at that point for some reason. Finally, you have a $200,000 lien on a $450,000 property. Some are recommending a real estate attorney. I think you need a consumer debt attorney. In order to take the property from you, the bank is going to have to take you back to court. At that point, you can demand they prove you owe the debt. They have to produce the actual loan documents or proper copies of the documents that have your signature. Statements, your cancelled checks, none of that actually shows proof if you are contesting in court. There is a very real chance the paperwork is gone and they have no ability to prove the actual debt. In that case, you can discharge the lien and sell the house for $450,000, pay your attorney, and keep the cash. This is the best case scenario, and you need an attorney that specializes in debt and foreclosures. And after the mess in 2008, there are a lot of them. So, what's the worst case scenario? You walk out of the house, vagrants take over, burn it, and the fire takes out all 3 of your neighbors and you're on the hook for $1.5 million. You need an attorney to guide you. It could be you own the place outright, or you owe more than it is worth. Only an attorney can really get to the bottom of this, and they can negotiate with the bank. You might be able to get out of this with some real money to buy something smaller somewhere else. They could also get you out with the shirt on your back, but no debt or liability hanging over you, and you can walk into something else. Don't be afraid of your situation. Face it head on, get some help, and deal with it. It will help you financially and mentally. Good luck. I guess personally, I agree with all this advice given. Considering the fact that I'm young and I don't know half the stuff that's being talked about here, I don't have any practical or good advice for OP, but hey, let's hope that no bums can break into his house and burn the whole lot down. It doesn't sound too practical. It kind of sounds like half the entitled parent stories that I read out, but that's my Markee 2 cents. You're free to fight me on that down in the comments if you'd like. Anyway, let's move on to the update. Colorado. What do I do with my house? Just leave the keys on the counter? I want to thank everyone for the advice on my last post and to give a brief update. I spoke to an attorney about it and she started looking into it. First thing she said is that I am still the owner and that the eviction process was never completed. She also told me that there's still a lien on the house, which is where it gets interesting. My mortgage was ultimately sold to a second mortgage company, which no longer exists. The second mortgage company that had my mortgage was absorbed by a third company, which went bankrupt and collapsed. Because I've been maintaining the property and paying property taxes, coupled with no lien holder asserting their rights, she believes she can get the lien holder removed from the title. So as it turns out, I may end up owning my home free and clear after all. Unfortunately, she doesn't know how long everything will take, so I don't anticipate an update for a while. But thank you all. And that one was posted 2 days ago. I obviously could go and message him and ask, but I think that's where we're at for now. If there is an update, I'll be sure to cover everything again in the future, give us a better idea of what's going on, but these things take months, weeks, years. Who knows when the next update's gonna come. Posted by user Dillamage, titled, "Can my parents force me to change my religion? I'm 15 and in Michigan State. My parents have recently converted to Islam and want me to convert as well. We were Buddhists before. I have no interest in changing my religion. They tell me that I have no choice because I'm a minor child. They want me to repeat a sentence after them, which proclaims me as part of their religion, and start living by its rules. I don't like the rules because they're too restrictive. Can my parents legally force me to repeat those words? Can they punish me if I don't? They have told me that for every week that I don't, they will take my things away from me, and after 10 weeks they will physically force me to say the words, and even if I resist, that I will be sent to an all-Muslim boarding school somewhere far away. I'm tired of this game, and just want to live my life like a normal person. Edit, thank you. I'm going to let them punish me and cross the line into abuse, then contact police and CPS to place me into foster care. What the hell? Physically forcing you to say the words, sending you to a boarding school out of the country, or taking away certain things like food may cross the line into child abuse, and you should contact a guidance counselor, child protective services, etc. Making you eat halal, taking away your Xbox because you won't be going to the mosque, and such would not though. So specifics of what they're doing and punishments matters. This is what they say which will be taken away. Week 1, all electronics. 2, all my clothes except one robe. 3, all my books except school. 4, all my school books. 5, my room's door. 6, my bed, blanket, pillows. 7, every single item removable in my room. 8, light and heating. 9, all food and drinks except bread and water. 10, I'll be sent to boarding school. Have they put this in writing? At some point you can call CPS. If you're in public school, you can ask the guidance counselor about where the line would be in terms of unpleasant parents versus abusive parents. Yes, it's on the fridge. Get a photo with your cell phone. Send a copy to a friend who is not in the community for safekeeping. Thank you, it's done. Weeks 4, 6, 8, and 9 are all very problematic. You should contact CPS, although be aware it may mean ending up in the foster system. I prefer the foster system. Okay, so if I let them do those things to me, then contact CPS. Is there a chance they'll get me out of here? CPS will generally try to work with your parents to correct their behavior first, and resort to removing you from their care if you're in immediate danger, or if your parents are unrepentant and persistent about depriving you of basic necessities. It's not anywhere near as simple as call CPS, end up in foster care. But if your parents, for example, deny you a bed, or refuse to feed you, then CPS can absolutely intervene to protect you. What if they beat me up? Well, that is an imminent threat to your life, and you can call the police and or CPS. If you have physical bruising on you, it violates corporal punishment laws in every state in America and counts as child abuse. Realistically, they can't force you to say anything. Practically, they can make your life very difficult if you don't, based on the fact that they're your parents and have pretty broad authority over punishing you for not following their rules, so long as their views don't grossly violate the law. They can't force you to believe, but they can force you to go to religious services, for instance, and can enforce whatever rules the religion prescribes. Here's what you're going to do. You're going to get a note or a copy of it. You're going to report all the crazy crap your parents have threatened to your school counselors at once, including the story of a girl being smuggled to Mexico and then Saudi Arabia. And you're going to tell them you fear for your life if you return to your parents. Make it very clear you feel if you return that you will be kidnapped and killed. At your age, they will likely support you being kept somewhere safe. And you know what? I think that's very good advice. Obviously, that last one seems like a huge overreaction, but hey, if you're getting that vibe from your parents, and you know them as the kid, and you know that's something that they would do, why wouldn't you take every step to protect yourself and save your own ass in this situation? I feel like that edit that OP gave us, that's a very heads up play. It seems extreme in a lot of circumstances, I understand that, but if you felt your life was being under threat because you're being forced to do these things and you don't want to, and they're going to deprive you of all your basic human rights, why wouldn't you? Why wouldn't you do what they're doing? Anyway, let's move on to the update. Posting an update, I am finally in foster care and away from parents and community. I'm happy I never said the words and never converted, but my life has been hell in the last 9 months. My parents did all the things that they said they'd do to me, and a lot more. It became even more violent, which my mum always denied, and said they're self-inflicted. After several CPS visits, I am now taken away from them, and my father is being charged with domestic violence, and I think my mum is also facing charges. I've been in foster care for a few weeks, and it's nice to be honest. Other kids in this home are also nice, and at least everything is normal and I feel safe here. I hope I don't have to go back. Posted by user Pass the Butter. Titled, Massachusetts. Hospital placed a wire in my arm to track me without my knowledge or consent. Photo included for proof. I have called multiple law offices, but no one is returning my calls. Somebody please help me. About 3 weeks ago, I was admitted to a psychiatric hospital due to various problems. It's a long story, but the short version is I have a psychoaffective personality disorder and I was not taking my meds properly. After I was stabilized, I was discharged, but it has come to my attention that something is terribly wrong. The hospital has placed a wire in my arm that I believe acts as a tracking device. It is quite obvious, especially when I flex my arm. I can see it bulge in my wrist. I've tried to take a picture, but IMGA is not letting me upload. This has caused me great distress. I stay locked in my house because I'm afraid of going somewhere or doing something quote-unquote wrong and getting forced back to the hospital. I've also become concerned about my medications. If the hospital staff inserted a wire without my consent, what have they done with my meds? I have Zyprexa and Haldol, but I dare not take them now. I have a few questions about the legal aspect of all this. 1. The insertion of the tracking device without my consent. Surely that's not legal. My understanding is the patient has to consent before a medical procedure is done. 2. The distress caused by this. Does that count as damages? Should I sue? 3. How on earth do I get the wire removed? I don't have money to pay a surgeon to remove it. Can I get the psych hospital to pay for it? I called several law offices in my area and explained my case, but no one has called me back. I feel so violated and I'm getting desperate. Please, somebody help me. Hi OP, I'm a mental health lawyer. It must be very distressing to you to believe that you are being tracked. Importantly, it is very insightful of you to recognize and acknowledge your mental illness. Do you have a mental health team that you are working with in the community that can help check in with you about your concerns? Alternatively, do you have a GP who you can check in with to speak about your concerns? Hello, I have a psychiatrist, a counselor, and a case manager. It being the weekend, I'm not sure they are available. The agency they work for does have a 24-hour crisis line, but I'm not sure who is on the other end of the phone. I have a GP, but I have not seen her in a while. She basically just prescribes my blood pressure medication. In any case, I've been talked into calling an ambulance, so I guess I'm going to the ER. That's probably best because I can't leave my house to get groceries, and I haven't eaten in a long time. I'm really proud of you, OP. I can only imagine that this is very scary for you. The ambulance option is perfect though, because they will be able to help you get directly from point A to point B. Once you get to the hospital, the doctors there can hopefully sort out your concerns about your arm, and adjust your medications to help you feel better, not to mention get some food in you. Let me know how it goes, okay? After you're seen at the ER, you can call your psychiatrist's office for a follow-up appointment. Make sure to mention that you have been seen in the ER recently, that they have been able to get you in quicker. The ER will be able to help you with immediate issues, and the follow-up with your psychiatrist will be able to find a long-term plan. This is a perfect example of client-centered support, pure validation with the goal of guiding folks in the right and safest direction. It starts with a healthy dose of empathy. That's something a lot of medical care can easily miss. Compassion fatigue is a serious problem that administrators and supervisors are rarely trained to address in their subordinates. Hi, electronics engineer here, and I am not a lawyer. I don't think the technology exists to make a tracking device in the form of a thin wire. This literally only exists in sci-fi. To do tracking, you need some sort of way to receive an external signal, such as GPS. A GPS antenna capable of receiving the extremely low power signals from the satellite versus just receiving noise would definitely not fit in a wire. A battery or energy source to power said tracking device would also not fit in a wire. First of all, thank you for taking the time to share your situation with us. I am sorry that you are suffering. I would like to share some advice so that you may have some relief. Is that okay? Not a lawyer, but I've worked in the mental health field. I would like to share my thoughts about your situation. Is that okay? I feel that a trip to the emergency department would be the quickest way to resolve this situation. A physician can assess your arm and determine the best course of action. They can also adjust your meds, and you will feel much better when they do. If you're afraid to leave your house and drive to an ER, call an ambulance. That's what they are for. They will take care of you. I'd like to share something with you. I feel that you are a good person. I feel that you want the best for yourself, and that you will take the best course of action. I have outlined one such course above. Please seek medical help, OP, and thank you for following my advice. Thank you so much for your kind words. It is nice to hear. My concern is that the ambulance crew will take me back to the same psych hospital that installed the wire. Thank you for sharing your concerns with me. I'd like to assure you that the ambulance will take you to the nearest emergency department, not a psych hospital. Okay, how can I call an ambulance? Just call 911 and say I need one? I've never done this before. Yes, tell them you need a ride to the hospital because you have a foreign object in your arm and you've not eaten anything in several days. This was incredibly well delivered advice. This thread has been really inspiring that all you folks have done amazingly. I really hope the OP is getting the help he needs now. And OP put an edit in their post that says, "Thanks to everyone who has talked to me. I guess legal advice is not really what I needed. I'm calling an ambulance and getting help." And they didn't put an update further to this post, but I don't think that an update further on would be appropriate. The OP seems extremely mentally ill, and their post history reflects that, so I think we have to respect their privacy and say they got the help they need, they got really good advice in this thread, and we can move on to the next post. Posted by user Oh Snappadoodles, titled, "Bonus Wages Taken Away After Hours Worked." I posted this in Personal Finance, and they suggested I post it here in Legal Advice. I also wasn't sure which flare to choose. I live and work in Nebraska, and I'm curious if this situation is kosher at all, as a lot of my coworkers are upset about it. Over the last few months, my work has offered a shift pickup bonus. If you pick up a shift, you get extra money on top of what you would normally make an hour. Other than saying we get a bonus for shifts picked up, there has been no other communication about it, and everyone who picks up a shift, FT, PT, or PRN employees, have been getting the shift pickup bonus. Until today. One of the higher-ups texted all of the PRN employees and informed us that we no longer get shift pickup bonuses because we don't have scheduled days, and work when we can. Definition of PRN. This seemed okay because sometimes they stop doing the bonus to bring it back later, but then they sent a correction text to tell us that for the previous pay period, no bonuses will be paid out, as it is our new company policy that no one in my facility knew about until today. They are taking these bonuses away after we have already worked the hours and pay period has ended. Until today, all employees worked under the assumption that they would get the shift bonus for any shift picked up and pick up shifts to get the bonus. A lot of my co-workers worked a lot to cover rent and other bills, and now this money is being pulled out from underneath them when they expected to have it. I could understand if this policy went into effect as of today, since no one knew about it, but to take the money away for days worked before today seems cruel and not kosher to me. What does anyone make of this situation? And yes, I have covered this one before, but it came up again, and I want to cover it again. The wording of the original policy is going to matter here. If PRN employees don't have scheduled shifts, then how are they able to pick up a shift? Qualifying for the bonus? Unfortunately, I don't have a picture of the notice that was taped up on the door in the break room, but the gist of it said pick up bonus for shifts picked up. It did not specify that it was shifts picked up on top of scheduled shifts. It has always previously worked that any shift picked up would get the bonus. They are informing us today that that is no longer the case, but it starts from 2 weeks ago instead of today. Any shift we scheduled for ourselves or were asked to work, we got a shift bonus for. The context of what the phrase shift picked up means and the job is going to matter. To me, that sounds like picking up an open shift, i.e. an unfilled 8 a.m. to 2 p.m. shift on the calendar. It wouldn't mean showing up for your regularly scheduled shift. If your job doesn't have shifts, then I'm not sure how you would even expect to pick up one in the first place, but that's going to be more arguable. Up until today, shift picked up was any open shift that needed a CNA. PRN employees don't have a regular schedule. They write their name on the schedule where open shifts are and work that shift, and would receive a bonus for every 4 hours worked. So all PRN staff that wrote their name in for a 4+ hour shift would get the bonus. Up until today, when we were told no more, and by the way, it goes back 2 weeks to a pay period that ended already. From what you provided, it doesn't sound like PRNs were excluded until the policy changed. Their screw up, not yours. You should ask for the money for previous hours worked. You can file a wage complaint with the DOL if your employer disagrees. Thank you. I don't think they can take away a bonus after you've already worked the shift in question. You agreed to work that shift for a particular wage. They can absolutely end the policy for PRN employees in the future, but you worked those hours in the past expecting to be paid that bonus. Just how far back do they think they can claw that back? Yeah, they can absolutely take it away. They take it away and bring it back a few times throughout the year. They are clawing it back 2 weeks to an already ended pay period that we are getting paid for this Friday, so the 5th to the 8th, I believe. This seems illegal, based on everything I've read on here concerning wages. Basically, they're trying to change your rate of pay after you've worked a shift, and as far as I know, that is illegal. If they think this is legal, what's to stop them from going back an entire year? Contact Nebraska DOL. Thank you. I anticipate filing a wage claim and have told the other PRN staff to do this also. And now, update. Bonus wages taken away after hours worked. Update to this post. Even though my original post only had a few comments, I wanted to post an update because the few people who commented really helped. I filed a wage complaint last week and encouraged my fellow PRN aides to also file a complaint. In total, 7 of us filed a complaint with the NDOL. I received an email back from DOL pretty quickly, with them asking for a lot of info and documentation about my side of the story. It was pretty late on Friday, so I didn't hear anything back until today. Before I heard back from NDOL this morning, I got a text from the person who texted all the PRN aides, who was just a messenger for the main admin person, telling me I had a check waiting for me in the office for my bonus money. About 10 minutes after I got that text, I got a call from the person who took on the claims that were filed. She let me know what my company was trying to do was not legal and that I should have a check waiting for me. She told me 7 of us filed a complaint and she reviewed them all and sent the admin a letter saying they couldn't take those bonuses away from us. PRN staff no longer will receive a bonus as of last week, but that's okay. Overall, this whole process ended well for the PRN aides. Thank you to the commenters who walked me through this and let me know this wasn't legal. We probably would have let this slide if I hadn't asked for help. Edit for location bot, this is Nebraska. Texas. Is it illegal to pretend to offer someone a job in the hopes to make them unemployed? This all happened a week ago, and I have found other employment, so that answers the question everyone's going to ask. Guy who used to work with us a few years ago left on very good terms. He got his MBA and went on to another company at a salary requisite to his skill level. Today he comes back for an interview at the company for an AVP position that is a small step up for him. Everything went well in the interview and everyone was on board. Problem is that the EVP said he is not going to give him the position. He's going to lead him on and make him think he has a job until he hands in his 2 weeks at his current position. Then my EVP is just going to pull the job offer with some bullcrap excuse. When I asked him why he would do this, he said the most important lesson I can learn in life is loyalty. Stay loyal or never come back. Yeah, I went ahead and warned the guy about it and told him not to put in his 2 weeks notice. He wants to go ahead and go along with this whole charade just to see how far the EVP will go. My question is this in any way illegal? I know that a company can pull their rug from under you in a million completely legal ways, but if there is proof that it was malicious, what can be done? Thinking about going to HR with this, then a lawyer if they don't do anything about it. Either way, I will never work at a company he works at again. Does this EVP have a boss? This is ripe for promissory estoppel / detrimental reliance. With an affidavit and testimony form, you, the candidate, has a case if he puts in his notice and loses his job. Screw that guy with a rusty railroad spike. What an absolute arse. If you have an independent HR team, a compliance hotline, or a general counsel, now might be the time. Also, anyone who's so focused on loyalty that they're willing to pull this is almost certainly going to regard you wanting the guy as disloyalty, and he'll definitely regard you testifying / going to the HR / notifying general counsel as disloyalty. And he's obviously dumb enough to ignore minor issues like legality. So be prepared for retaliation. CYA, document everything, and be prepared to give him another rusty railroad spike after he fires you for snitching. Already have a new job, as does half of the staff under him. Just for clarification, there is no legal case until someone suffers actual financial damages. Going along with it to expose the practice isn't necessarily enough, unless the candidate genuinely loses current job and didn't know about the fraud in advance. However, litigation is always expensive for companies, and the senior executive management team may want to address this practice, just from a risk management / mitigation perspective, given that you have a new job and you might not care. Plus, if the candidate goes along with it and loses their current job knowing about the EVP's intentions, that may impact their legal outcomes. Promissory estoppel and detrimental reliance are both equitable, and some courts are quite reticent to give equitable relief where a plaintiff seems to have contributed to the result. Unclean hands, even if they didn't do anything particularly wrong. I can't speak for Texas specifically though. Playing along to document the practice for the EVP's superiors is completely fine, of course. Just best not to resign in the process. My brain checked out about halfway through that, so I don't have anything to say about that. Besides being a terrible business practice, offering someone an offer that you know isn't real in the hopes of causing them financial harm could be considered fraud. There is no gain here for the EVP. At most, this falls into the land of detrimental reliance, except the friend knows about the plot now and is willingly going into the fire. Dienda says, gain is not an element of fraud. The guy's knowledge of the plot can eliminate the actual and justified reliance element though. In order to prove fraud, a plaintiff must show that 1. The defendant made a material representation that was false. 2. The defendant knew the representation was false or made it recklessly as a positive assertion without any knowledge of its truth. 3. The defendant intended to induce a plaintiff to act upon the representation, and 4. The plaintiff actually and justifiably relied on the representation, which caused the injury. Very interesting stuff. Savage Ark says, it isn't illegal, but you can sue over it. If you made substantial life changes, like quitting your current job, moving, etc., in order to accommodate a job offer. Comedy option, intentional infliction of emotional distress. And last one, lawyer here, not in Texas and not in employment, although maybe contract, attorney either. But this is a great way to get your ass sued, like home run, do not pass go, winner winner chicken dinner. Am I mixing these up? It literally checks all boxes. Illegal is a strong term. No one goes to jail for this, but you get sued. And a smart company will fire someone who acts like this. Indicates immaturity, pettiness, and an inability to separate work and personal. Again, this isn't really legal advice. And yeah, like some comments are saying after this, if he signs a letter of employment, can't they not do this to him and like he will get sued for doing that? Just seems stupid, but okay. Update, D-bag boss wanted to screw over a former employee with a fake job offer. Went to HR this morning and played the audio from the phone call. I also pulled the emails between me and the EVP and handed them over to HR. The chief personnel officer pulled me into his office and made me play everything for him. I told him the full story of everything about the former employee and the EVP's attitude. To make him completely understand that I would not let this get buried, I told him that the former employee knows the whole thing. Said that I plan to leave at the end of the week if the EVP situation does not get handled. Did not tell him about the new job. The CPO thanks me for my honesty, which by the way was a major red flag for me, and said that he would be contacting the COO immediately. At lunch, I was pulled into a meeting with a junior HR person to talk about my performance review. We do not have performance reviews. It went badly. I was given 5 minutes to pack up my things at my desk and leave. I had an email typed up on my phone and sent it to the CEO detailing everything. I had typed it up as things happened and pretty much knew I would be cut today. Luckily, my access had not been cut yet, as I received the CC to my personal email back almost immediately. It received a one-sentence response of, "Thank you for bringing this to my attention." So all in all, I'm pretty sure they will not do anything. They just do not realize how many people are leaving with no notice Friday. A large number of people know. Oof, that doesn't sound good, but hey, what can you do in this situation? It's a bit of a tease ending, I'll admit, but I like it. I like that ending. Good, screw that job. Posted by user Throw Legal Advice Dogs 29291, titled, "Neighbors entrusted me with looking after their pets and house for 3 weeks. It has been almost a year now, and they haven't come back. Today their basement flooded and I have no idea what to do. In June 2019, my neighbors came to my door. I had some experiences with them. They invited us for a barbecue not long after they moved in. They asked me and my wife if we would look after their pets and their house for the next 3 weeks, as they needed to return to Taiwan as his mother was dying. They even left me $500 for food for their 2 German shepherds and their cat. I don't know what happened to them, but they just never came back. I don't know if they ended up in some sort of prison or just decided not to come home at all. Today I found out their basement had flooded, probably sometime within the last week. Apparently a pipe burst, but the entire basement is completely screwed. I paid to have the leak fixed, and I spent all of today using my shop vac to drain their basement to the best of my abilities. Between this and one of their dogs needing surgery, I have spent several thousand of my own dollars, and frankly, the damage to the basement was pretty awful. I don't have their insurance paperwork, and I don't really know if I can even do a claim for them. On top of this, his 2 giant German shepherds, while they're amazingly good boys, it is becoming almost too much for us to handle. Their last name was extremely common, and their Facebook profiles are private, which gives me very little avenue to tackle this down. Timeline: June 7th, 2019. Neighbors asked me if I would look after their pets and their house while they were handling the death of his mother back in Taiwan. Told me 3 weeks at latest. July 1st, 2019. Neighbors sent me an email stating they needed some additional time to handle his father's affairs. He apologized and said he would be back by July 15th at latest. July 21st, 2019. Sent him an email asking what was going on, explained how we were going on vacation in August, never got a response. July 31st, 2019. Tried calling him on his cell phone. The number he was given to me was no longer in service. August 14th, 2019. Went on vacation. Had my brother look after all 4 dogs for the next week. September 2nd, 2019. Emailed him again, no response. September 3rd, 2019. Tried to reach him and his wife via Facebook using the private message feature. September 6th, 2019. Ended up moving his 2 dogs, 1 cat, into our house as they seemed extremely miserable. I ended up disassembling part of our adjoined fence to allow his dogs to use their outside area. November 19th, 2019. One of his dogs started showing signs of being ill. Brought him to the vet. Turns out he is suffering from a medium severity case of IVDD. He ended up requiring surgery, which we paid for. January 21st, 2020. Sent another email and never got a response. Today, when I was bringing his mail to his house, I noticed it smelled pretty awful, and I noticed his basement had about a foot of water in it. Questions. What exactly is my level of responsibility in this? I agreed to look after it for a few weeks/couple of months at the most. It has almost been a year now. Is there anything I can do? Location: Ontario, Canada. Oh my god, of course it's in Ontario, Canada. Sorry, some other points. I am assuming they have some sort of auto payment for bills set up, because they still have hydro cable and internet. I am unsure where exactly the husband worked. I know he said he was an engineer, however I cannot find his LinkedIn profile, so I don't know what company. Their last name is a very common name, common like Wong, which gives me tons of Facebook results. Report the people missing. Right? My initial thought when they said they were emailed that they needed a bit more time, then they went AWOL, made me wonder if they died. If they had no intention of returning, they could have just said something like, "Something came up and we can't come back. Please keep or find a home for my pets." Especially if they own a house there. Why wouldn't they hire someone to sell it if they weren't returning? Exactly. And even if by some freakish turn of events, they were wealthy enough that they would just up and leave a property, they certainly wouldn't keep paying to keep the utilities on. I'm surprised that this is the only comment here saying this. It might be abandonment, but it could also be that something happened and they're dead or stranded in Asia. I would also add that if there is no one in the home, it would be prudent to go ahead and shut off the main water and, weather permitting, gas valves. This would eliminate any chance of future leaks and possibly worse. Property tax records would have their full names, assuming they own. You should contact the police and tell them what's going on. I know their full names. It is just that their last name is extremely common and their Facebook profile is private, so I have no idea who's related to them. I'll contact the police tomorrow. Thanks. Contact the Taipei Economic and Cultural Office in Canada. That is their embassy. They can find out what happened. It would be a good idea to talk with the lawyer. Give him the lowdown on what's going on. Do you want to be able to cover all your bases so they possibly can't turn around and sue you for something or other? Do you know any kind of lawyer I should be looking for? Can I recommend you contact the dog's breeder before the authorities? Once you start that particular ball rolling, the dogs may enter some weird limbo or possibly even be taken by animal control, simply as a matter of practice. Hopefully not, but you never know. As has been said, any good breeder will take these dogs back pronto, and that will almost certainly have been stipulated in a contract. My owner's dog breeder tells a story about the 9-year-old dog she took back after the owner died and the spouse simply didn't want him anymore. But I'd research that breeder online and then reach out to them. Breeders can be amazingly resourceful anyway. Good ones, and you seem to care about these dogs. By the way, you seem like a very good egg. Those dogs are lucky to have you. And this is the last comment thread of advice I'm going to read. You have no responsibility for the house, so ignore that for the moment. You have no legal responsibility for the pets, but I'm assuming you are attached to them, so don't want to turn them over to the animal control. I have to say that you sound like the neighbor from heaven, but your only responsibility in this situation is to actively avoid causing harm. You don't have to do anything to fix the house or even mitigate damages. In my view, the only thing you need to do is consider how to handle the animals that have been foisted upon you, and that's it. I will be honest, I love his dogs. However, they are 2 massive German Shepherds who were never trained. They are extremely high maintenance animals. Both me and my wife have full-time jobs, while thanks to COVID we can work from home more often. Just taking care of them is becoming almost too much. We have 2 smaller dogs, a Corgi and Jack Russell, who do not really get along well with them. If I was to turn them to the animal control, would that be possible? If you want to do right by the dogs, look for a breed-specific rescue in your area. Far better outcomes than just generally turning them in. Thanks, that is actually a great idea. I know what breeder they got their dogs from as it's on the fridge. Return them to the breeder will find them a loving home. No good breeder wants the dogs they produce to end up in a shelter or rescue. And I think that's all really good advice, honestly. I think they should take that advice and run with it. And now for the heavily rewarded post of the update to that story. Good news. I followed everyone's advice, reached out to the police and the embassy, explained the situation, and gave them a bunch of information. Tonight, I got a phone call from them, explaining they just decided to stay much longer and spend times with family and friends. They apparently asked his wife's brother to come and collect the animals and get the key a long time ago back in August, but never followed up on it. He apologized and said he was sorry. He gave me 2 options, and asked if I wanted to keep his pets since I've had them for so long, or he will push his stepbrother to get the animals. Apparently, the animals don't really mean anything to him or his wife, which I feel is quite crappy. He apparently can no longer access his email and passed me along a new email address and phone number I can use to contact him, but told me he doesn't have plans to return to Canada anytime soon. I mentioned the water damage, and he said they can just buy a new house or get it fixed when they get back. He was also quite confused and somewhat annoyed about the lengths we went to get in touch with him. He didn't understand why we reached out to the embassy. He then offered to send me a bunch of money to square away the inconvenience, and that was more or less it. I don't know if it's a cultural thing. However, I feel kind of ticked off at how little he and his wife seem to care about the pets and his house. Anyways, me and my wife are going to keep the pets simply because, well, I don't think either of us can part with the dogs and his cat at this point. Oh, that's a really good ending to this one, I liked that. Posted by user MetroDZS, titled Maryland, taken by EMTs against my will. I was out at the bars on Thursday night in College Park, MD. It's probably Maryland, isn't it? Apparently, I had a bit too much to drink and don't remember anything that happened that night, but I do remember waking up in hospital the next morning. Apparently, a video was taken of me, which I now have a copy of. In the video, you can see me lying on the ground in the parking lot next to the bar surrounded by cops and EMTs. In the video, you can see the EMTs kneeling down next to me and asking me questions, and you can clearly hear my yelling at them to leave me alone and don't touch me. They ask me if I want to go to the hospital, and in the video, I yell that I do not want to go and that they need to leave me alone. They keep asking me questions while I keep telling them to get away from me until they ultimately decided to load me into the stretcher by force and take me to the hospital against my will. I want to sue the Prince George's County Fire Department, the College Park Volunteer Fire Department, Inc., the individual EMTs who took me against my will, and the person who filmed me. The problem is, I don't know the names or the identities of those individuals. I called the College Park Fire Department to ask about it, and they basically stonewalled me, and told me to call the Prince George's County Fire Department Office of Public Information, which I did, and they only stonewalled me further and wouldn't disclose the information I need. How do I force the fire department to disclose the identities of the individuals who violated my rights? Edit. I now see that posting here was a mistake. You guys aren't very helpful in any event. I still fully intend to sue. Oof. Oh my god. You have nothing to sue over. You were so intoxicated that you were a danger to yourself. Your consent is not needed in that situation. Your consent is never needed to film you in public. They charged me for a service I tried to refuse. You voluntarily rendered yourself incapacitated. Medical treatment is under implied consent if you are unconscious or otherwise so intoxicated that you cannot make your decisions. Voluntary versus involuntary doesn't matter with implied consent. OP could have been slipped something, and he still wouldn't have been able to refuse transport. Voluntary does impact financial responsibility if he had been drugged against his will or without his knowledge that that person would be liable for his costs, although he would still ultimately owe the medical provider. That's called an implied contract. A reasonable person who is in need of emergency care is presumed to be reasonable enough to not refuse. In this case, the reasonable person is you in a sober state. What you said while drunk is irrelevant. I'm not judging you, but the way the law sees it, it doesn't matter if sober you still thinks they should have left you there. The law is concerned with what a reasonable person would do, and a court will be happy to conclude that sober you is not a reasonable person. Oh my god. If a judge finds the testimony of the officers and EMTs to establish that there was a substantial chance of you suffering irreparable harm while in that state, then the judge will likely conclude that their treatment of you was lawful. Why didn't you just get up and leave the parking area before they took you? Because he was blackout wasted and probably was unable to do that. Exactly my point. Sorry, some stuff is going to repeat, but it's good to just drill this lesson in. You are blackout drunk. You cannot refuse medical treatment when you are that drunk. And you sure as crap can't sue someone for filming a drunken idiot in public. They cannot take me against my will. I was not under arrest. And they have the audacity to charge me $500 for a service I didn't want and even refused. Yes, they can do all of those things. Not only are they allowed to do that, but once you get to the hospital, they are allowed to physically restrain you and chemically sedate you if they believe your behavior is a danger to yourself or others. and they'll charge you for that too. Medic here. I do what they did to you at least once per 10-hour shift, usually more. Have yet to be sued over it. My advice is let this be a lesson learned. Don't drink to incapacity. Believe it or not, people do die of alcohol poisoning, or by choking on their own vomit. And now, update. Maryland, taken by EMTs against my will. For those of you who may remember me from a while back, and for those of you who read my original post just now, you're probably wondering why I'm bothering to post this update in the first place. I'll get into that later, but the short answer is that I believe the responses I received to, and the subsequent consequences of, my original post here, played an important role in causing me to do a serious amount of self-reflection, which resulted in me making serious positive changes to my life. I suppose you could even call this update a thank you of sorts. Anyways, on to what actually happened after my original post 8 months ago. As my edit to the original post implied, I did not get what I want from the original post. What I wanted was a bunch of people to tell me what I wanted to hear, and to provide an escape from the consequences of my own reckless behavior. What I got was a whole lot of people reminding me that there was no one to blame but myself, and that I had to face the consequences of my actions. Naturally, I refused to accept this, and went ahead and consulted a lawyer. I say consulted for the lack of a better word, as it was more like said lawyer showed me the door shortly after I pleaded my case. This, however, did not deter me. If anything, it only invigorated me further. I decided on pro se representation. The first step was, of course, collecting evidence. And by collecting evidence, I of course mean showing up to the fire station that housed the ambulance that picked me up drunk and demanded the information I wanted. Luckily, this was at approximately 3 a.m, and only one firefighter was awake at the station at the time. I suppose I should count myself extremely lucky, as he did not immediately call the cops on me, but instead sat there patiently and listened to me as I screamed unintelligible nonsense at him. Even offered to give me a ride home using the department's utility truck. Needless to say, I did not acquire the information I sought out, so I returned home and passed out. When I woke up to a crap storm. The original post I had made here had apparently been cross-posted to another subreddit, which somehow led to me being doxxed and humiliated by almost everyone who knew me. Even my boss laughed at me. Suppose I should be grateful that I wasn't fired. In any event, the humiliation led to me taking a step back and looking into my life with an outside perspective. I hated what I saw. I hated it so much that I swore to myself that I would change, and somehow I did. Sort of. I never actually ended up filing anything with any sort of court. Good thing too. Would only have served to waste my money and humiliated me further. I came to the conclusion that I was a functioning alcoholic. A few months ago, I began to try the Alcoholics Anonymous route. It was hard, and I released a few times. But as of posting this update, I am over a month clean. I don't really want to get into the details of my recovery, but needless to say, the slap in the face I got from the doxing of the post I originally made here really helped me out. I won't bore you guys with the details of how I proceeded to clean up my life after that, but I consider myself a seriously different person than I was 8 months ago. And it's all due to a chain of events that was born from the original post I made to this subreddit, and for that, I'd like to thank you guys. I suppose I don't have a single reason for actually posting this update, but I hope you guys know that your advice does help people, even if it may not be in the way originally intended. I'd always like this story to be an example for others in situations similar to mine. Really makes true the old saying that if everyone else at the table tells you that you're drunk, then you probably are. Yeah, that was beautiful. That was really well written. 96% upvoted. Very good audience. And I think, there's a lot of good lessons in that one. Girlfriend received a DUI in a car that only had 3 wheels. This is in West Virginia. Throwaway because she knows my regular account and wouldn't want anyone else to know about this. My girlfriend and I went out for dinner, then bar trivia and drinking. I only had a few drinks the whole evening, but she had 5 to 6 mixed drinks and was very drunk. When it was last call, I decided to drive her to her house in her car, then Uber back to my car and go home myself since I had work the next day. I put her in the passenger seat of her car and started driving to her house, but on the way, I hit an awful pothole and busted a tire. I pulled over in a parking lot and started to change the tire, but left the keys in the ignition so she would be warm since it was pretty chilly out. I jacked the car up and was proceeding to change the tire when a police car pulled into the parking lot, and I thought he was going to help me out, but instead he asked me if I was drunk. I told him I wasn't and explained I was taking my girlfriend home since she had been drinking. I took a voluntary field test and breathalyzer and blew under the limit. He then looked into the car and saw my girlfriend half asleep in the passenger seat and asked her if she was drunk, and she said she was just sleepy. He then made her get out of the car and do a field sobriety test, which she failed, and then the breathalyzer, where she blew a .10, legal limit in the state is .08. He then placed her under arrest because the keys were in the ignition and she was the only person in the car and intoxicated. Please note that at this time I had not finished changing the tire, so there were only 3 wheels in the car at the time. He took her to the city station, and after I fixed the tire, I went down and bailed her out. My question now is if it was actually a DUI. It seems very silly to me that she was charged since she was buckled up in the passenger seat and there was only 3 wheels on the car at the time. We don't want to go through the first-time offenders program if possible, since it requires a plea and she is afraid it could affect her graduate work at university. Thank you. You should get an attorney. If you're being 100% honest, don't accept any plea deal either. This sort of police behavior falls directly under revenue generation. I know it sounds ridiculous. I couldn't believe it myself. The thing is, this is a large university town, for the state at least, and all my encounters with police before then have been run-of-the-mill. We've narrowed down to a few attorneys at this point, and I'm checking options before we call Monday or Tuesday. As long as you were actually the one driving, then this case will most likely be thrown out. While the officer can charge someone for being in a vehicle with the keys in it and running, in this case, you were obviously changing a flat, and she did not have control of said vehicle that was immovable at the time. You might need an attorney, but it will save you time and money in the long run. What's critical is that your emotions not get involved. You're 100% in the right here, and a vaguely competent lawyer will get this discharged. That's a bad cop. A good DUI lawyer will take care of this. Just needs to be presented to a judge. You admitted you were the driver, you blew under the limit, your girlfriend was buckle upped and passed out in the seat. There is nothing illegal about driving drunk people home. In some areas, you can be charged with a DUI if you're in a car with the keys in the ignition, even if it is not moving. So there may have been legal grounds for the arrest. However, this does seem like an abuse of power given the circumstances. So get a lawyer, and I'd recommend one that specializes in something like DUIs or criminal defense. Just curious if you would know the answer to this. Now that push to start is becoming the norm, and having the key in the ignition is impossible in some cars, could someone with keyless start be charged for having just their key in their pocket and be seated in the driver's seat? In New York, having the keys in your pocket is viewed as intent to drive, and the driver may be charged. It's a good answer, thank you. I think the vehicle missing a wheel and the literally driver of the vehicle being outside of the car makes the whole ability to drive while drunk part of the law pretty irrelevant. Nothing in my comment was disagreeing with you. I was simply pointing out that a lawyer is necessary because it's not like they can bring up the details themselves in court and get it thrown out. Cops should exercise common sense, absolutely. This was absolutely an overreach of power. But it's not simple because the law may be on the side of the officer unless there is a lawyer to argue for them. Also, as someone has pointed out, you can drive some distance on the rim of a car, so simply missing a tire isn't going to stop a drunk person from driving. And that's the sort of defense a lawyer is necessary to argue. Unless I'm misunderstanding OP, there wasn't even a rim and it was on a jack. If it wasn't on a rim in that state, the body would be riding on the ground. Definitely not a drivable state. Mr. Science Sold, you have definitely not seen some outrageous driving videos then, buddy. Barmer Breeze 505 says, this is known as an opportunity DOI. It typically requires establishing intent to drive while under the influence of drugs or alcohol. In the case of people with a history of DUIs, intent is as simple as having the keys and being within 25 feet of the vehicle. In less defined cases, it generally involves having the keys in the ignition. However, Given that the car was not in a drivable condition, there was no opportunity, and thus should be lawful. This sounds like an egregious reach for meeting in parameters. The grounds for arrest would only be warranted if the car was drivable. Even still, you driving her home is an example of you doing the right thing. Get a good attorney and hope that the cop accurately wrote his report. It should get thrown out, but the legal system is far from perfect, and the sad truth is that your girlfriend might have a DUI on her record over this nonsense. I goofed up, I thought there was an update for this, I'm sorry. We're moving on to a post with an update. By user, ErgDrive, titled, "Kid in school playground across the street threw a rock through my window. Is the school liable? This is in Illinois." So I live across the street from a private Catholic school. One of the students in the after-school program threw a rock into the parking lot where my car was parked, breaking a window. The falling glass scraped paint off the door directly under the window. The director of the after-school program left a signed note admitting that a student threw the rock that broke the window. Now they're trying to get me to deal directly with the parent of the student, who don't have the money and have told me to take them to court. I have a text message from the director of the after-school program stating that the parents have agreed to pay for the window, but that they have doubts about the resulting scratch. I have pictures from the night of the incident showing that it is fresh damage. Rather than trying to get the money out of the parents, which is all but certain to be a drawn-out legal process of garnishments, etc., is the school not the liable party here, and should I just file the small claims case against it? You would have to prove that the school was negligent in their care of the children and/or policies of the after-school program, which directly caused your damages. Would lack of appropriate supervision not be sufficient to demonstrate negligence? It would be very difficult proving a lack of supervision when the supervisor posted the note on the window. You could have a student standing next to a supervisor and throw a rock, and then run to get in line to come back inside. Things to think about. PE classes will have 40+ students and only one teacher. Using that formula, it would be hard to say that they would be negligent. Does the school have cameras outside? You could see if they have a copy if they do. You could argue that mitigates a claim of negligence against the teacher, but not against the school that determined that one teacher is sufficient to supervise 40+ students during an outside PE class. The State Board of Education allows class sizes of 40+, that's why they can do that. You then would need to go after them. OP said it was a private school. Missed that? Thanks. If the private school uses the guideline given by the State Board, would that cover them? They might be able to argue it as a professional standard, but I wouldn't expect that to work where I am. I don't know about it. This is why you have insurance. Just tell your insurer and they'll work out who it's worth suing. The lowest deductible I have had from homeowners is $1,000, which is probably more than the cost of the replacement. It sounds like the damage was to his car. His car insurance, comprehensive coverage, would be applicable. Also, you can ask if the parents have renters or homeowners insurance. Their liability coverage would pay for the damages. Liability coverage does not have a deductible for the policy owner. The parents wouldn't have to pay, but may have their rates go up. One of the parents does not have homeowners insurance, and it's the same parent who has told me that they don't have the money to pay for the repair and to take them to court. I'll go that route if I have to, but I'm trying to avoid having to squeeze blood from a rock. OP also says, between my deductible being higher than the cost of the repair and my already high premiums by virtue of being a newly insured young male driver, I'd rather not file a claim with my insurer for something like this. Not a lawyer, but a parent who manages after-school programs for our elementary school. Because these programs take place outside of school hours, generally by private companies or non-profits, we require them to carry their own insurance before they're allowed to conduct their program on our grounds. Not sure if your situation is similar, but it might be worth finding out if their after-school program is run by a third party whose insurance could certainly be easier to deal with than the school's. Not a lawyer. When my wife's car was hit while it was parked, our insurer told us it was our property damage, since her car was parked at the time of driving. As a result, the other person was responsible 100%, didn't use her deductible, and didn't change her premiums. I wonder if the same rule applies here. My only hang-up is that it wasn't another car that damaged your parked car, but a kid with a rock. Update. Kid in school playground across the street threw a rock through my window. Is the school liable in Illinois? As an update to this thread for anyone interested or who finds themselves in a similar situation, the school ended up paying for all the repairs to my vehicle. According to my insurance agent, the magic words are custody, care, and control. The school was acting as a guardian of the boy, therefore it was fully liable for the damage he caused. Posted by user SayWhat63, titled, I really think that making out my will is going to kill me. My folks left me their house and property in their wills. Now a relative is pressing me to make out my will, even going so far as to offer to take me to a lawyer. I don't drive. Problem 1. By law, I need 2 witnesses. I don't want my relative to be one of them, but I also don't want to be upset or offend her by bringing along 2 friends of mine when she does take me. In the event that my friends are willing to help me, should I ask them if they're willing to bring me to a lawyer instead? Problem 2. In my parents' wills, it was stipulated that my husband will not inherit the house and property, etc. So my question is, do I have to stick by my parents' edicts, or can I, as the legal, deed-carrying owner of the house, ignore that part of my parents' wills and have his name put on the deed, thereby making him the first beneficiary? I tried to Google the answer, but I'm not very tech-savvy and might have looked right at the answer without realizing it. Any advice would be appreciated. A good estate lawyer, one you ultimately choose, not one chosen for you, will discuss different options for estate planning and give you time to think about which one is the best choice for you. If you think the relatives who's pressuring you is money hungry, watch your back around them. Ask about a revocable living trust instead of a will. Wills can be contested, trusts are much harder, if not impossible, to challenge. Take an Uber to the lawyer's office and they will provide the witnesses. You shouldn't involve other people in your will prep because family members lose their minds when money is involved. Your lawyer will handle all of the questions, that's their job, and they will help you. A witness need not be someone you know, and especially if they're relevant to the document being signed, they cannot legally be a witness, as to ensure no coercion takes place. Whatever I sign, I prefer to have people who barely know me witness it. Maybe one friend unrelated to the topic, and another provided by the lawyer, but that's it. Typically, having a will drawn up involves at least 2 appointments. One where you discuss what your assets are and what you'd like to do with them, and a second where you review everything and sign it. In my area, most lawyers have paralegals serve as the witnesses, so you don't have to bring anyone. If you can leave your inherited property to your husband, or make him a joint owner, is going to depend on where you live and exactly what your parents did with their estate. So bring your documents to the first meeting and discuss it with the lawyer. If your relative is making you uncomfortable, find your own estate lawyer and ride. But it sounds like you inherited enough that it's best to have your own will. Tofurkey Freakmitten says, I work for a law firm that prepares wills and estate planning documents. I do other work, mostly unrelated to that, but when we do will signings, the EP paralegal and I are the witnesses, not whoever shows up with the clients. We have done remote signings at hospitals, hospices, and rehab centers, and we almost always supply both witnesses, unless there is a reason we can't or aren't allowed to. I think you are worrying way too much about this. Have you considered a remote consultation? Plenty of attorneys are doing them under the current circumstances. My husband practiced in another state of Texas before we moved where we are, and there are special rules in place to permit video notaries for will sign-ups there. So it is also possible to do that remotely in a few places, I imagine. Edits, I don't know the relation of that person or whether they expect to be a beneficiary in your will, but if so, I don't think they would be permitted to witness anyway. 1. Not a legal matter, but there is no harm in having your friends take you, if that is what you are concerned about, nor is there any need for a witness to be a relative. So if you are more comfortable with them driving you, go for it. 2. More complicated. Wills can restrict future action with what is willed, but only to an extent. Ask the lawyer when you get there. They should be able to answer. You can also have the will include contingencies, i.e. a secondary beneficiary, in case the primary one can't collect for whatever reason. That would put the house problem in the hands of other people in the future, if it ever becomes relevant at all. And OP says, update. I'd like to thank everyone for your advice. Some folks have asked where I live. I'm writing from Connecticut. You have all given me not only great advice, but peace of mind as well. And for that, I thank you. I'm going to start making calls on Monday. And I think that's a really good ending to that one. That's really wholesome. Good on them for finding the information they needed. Posted by user Cloppy78. Titled, California. We are a small indie porn company. Former model wants her videos removed, unwilling to buy the copyright. Sends threatening messages. She worked for us between 2009 and 2012. She has 17 videos on our website, although we have recorded 20 and plan to release the other 3 in the future. This is more or less 10% of all videos that we have. She first came to us earlier this year and asked what the process is to have her videos removed. She's getting married and her husband is not comfortable with these videos of her being online. We have quoted her the price of $25,000 per video to purchase the copyright to the contents for the 14 of her videos. 3 of her videos are very popular among our members, and we have quoted $100,000 per video for those. We also quoted $20,000 for the unreleased videos, so overall it was $710,000. We gave her a discount and called it $700,000. Also, the contract would allow us to continue using the material for a further 12 months. This is to give us time to produce replacement content. This is more than a fair offer in the industry. She wouldn't be getting anything close to this offer from a big studio. She chose not to take our offer. She offered to pay $100,000 for the entire thing to be removed immediately, and we declined. She has, however, been sending us letters threatening legal action if we do not accept her $100,000 offer, saying we are violating the good faith and fair dealing covenant by not accepting her offer, and she will be taking us to court. The letters are not from a lawyer. Do we have anything to worry about? As long as you have a model release signed by her, you are most likely fine legally. With that said, she can still make your life difficult if she gets a lawyer to sue you. And of course, if this case gets attention, it will hamper your ability to recruit future models. Have you considered working out a payment plan with her or something along those lines? The flip side is the Streisand effect if she does sue. How would her future husband feel about that? I would think that going public would ironically increase the value of the videos. Did you see that girl in the news on that porn site? Like, just this post is increasing the value. Ah yes, the anonymous post with such critical details such as indie porn company, girl, and California. Until I read this thread, I didn't know that it was a thing. As someone who's sick of regular mainstream stuff, I'm a bit intrigued and may do a little sleuthing around the internet for this newfangled indie stuff. What the hell? OP also says, I didn't mention a payment plan, but mentioned to her that she can buy them one by one if the entire fee is too much, which will be similar to a payment plan. Until you are served, it is hot air. If you are served, don't ignore it. Now would be a very good time to get an attorney on retainer. You should have one anyway in your line of work. Provide the attorney with copies of all correspondence, contracts, etc., plus anything you can find to demonstrate the fair market value of the content. Consider having the attorney draft a letter to her demanding all correspondence be directed to the law office. Knowing that you are prepared to make a fight of it may be enough for her to back down. If you have $710,000 in assets at stake, you can afford a consultation with a real-life, in-person lawyer. Do so. Exactly. I find it troubling that a company does not have a lawyer. We were thinking we'll get a lawyer when she gets one if we are sued. But $700,000 isn't at stake because she won't pay for them. We're just hoping she would disappear without causing problems. In assets was the crucial word. Fair enough. The best defense is a good offense. Get ahead of the storm by preparing yourself legally. Act, don't react. Not a lawyer, but a player in the industry. Go get an industry lawyer's advice on this situation. Technically, if your model release is solid, the performer can pound sand, but it doesn't mean she won't become the biggest pain in the ass you've dealt with or start threatening affiliates if you have a program. They seem to love this, and I'm constantly forwarding mails to my AF reps to send up their pipeline. Are these all puns? These are really bad puns. Go to one of the industry forums and ask for a lawyer's recommendations if you don't know industry lawyers. Yeah, thanks. I think it's about time we start a working relationship with a lawyer. We had one who solved a few issues in the past, but that person has retired and we haven't had issues lately. I think it's the best way to go. Until she decides to actually file a suit, it's all threats. But when you start factoring the time and effort to deal with the crazy, that adds up just as well. The other thing you might want to bring up with whomever you go with is her spreading rumors about you guys and damaging your reputation. I'm sure you're just as aware as I am how much they love to spread damaging rumors. And the best comment in this thread by Sully618, D. Now on to the update. There is a lot to discuss. We did a little research and turned out her stories about getting married and her husband wanting the videos to get taken down were lies. She, in fact, is starting a membership program on her own website and wanted to use that excuse to get our videos at reduced prices, to post them later to her own website. Wonder if it's OnlyFans, who would have thought? She wanted to use the exclusivity to get some of our paid members and have a larger library at launch. Once she realized that we know of her plan, she offered to pay the full $700,000. However, we declined since we have no interest in allowing her to use our videos to compete with us. She even offered to pay $1 million if we agreed to take down the videos immediately upon the sale. We, of course, declined and informed her that we are no longer willing to discuss terms about selling our copyright. One other small studio that she has worked in the past with had already fallen for her lies and sold her the videos at non-competing prices. We're happy we didn't. We learned a new lesson. People lie in business to get better deals. Love that. Posted by user Doubts Within. Titled, I'm a pedestrian who waved in an SUV in a narrow gap and he got into an accident and he's threatening to sue me. This happened a few days ago. I live in Philly, and I was walking along a busy street, and I see this SUV at a one-way narrow street waiting to move forward at a green light. There is a small car ahead of him that's turning right. The SUV wasn't moving past the car because he thought he didn't have enough room. I saw that he did, and I just gave him a thumbs up that he can go. He ended up hitting the other car. He was trying to avoid the curb, I guess, and turned at the last second. They got into a bit of an argument and shared info and decided to call the police to make a claim, I think. I didn't really listen, but the other guy in the small car asked me to hang back and provide a witness in case he needed it since I saw the whole thing. They both shared each other's insurance and ID. The SUV guy asked me for my ID for witness too for his insurance claim. Soon after, he took a picture of my ID on his phone. He said I was the reason he moved and that he will have to make a claim against me. He is threatening to sue me and said that he would rather just send me the damage bill of both the cars. I felt bad because I gave him the thumbs up that there was room, but he did turn at the last second. The other guy was also annoyed that I shouldn't have told him to go. He called and left with a VM that I needed to act soon because if he makes a claim in court, it would lead to a lot of legal fees for both of us or something. He said that if I agree to pay, I can just pay half the damages. I'm worried that it's going to be a huge amount and I don't want to go to court. If it goes to court, will I have my credit ruined? Sorry, I don't know too much legal stuff. Edit. Now he is saying that my future will be screwed and my credit score is going to be messed up, and that there is a possibility that I may be criminally convicted. I'm an immigrant here on a visa, and I'm worried that it's going to affect me. Edit 2. Hey guys, thank you so much for your support. This has been really helpful. However, I am getting conflicting advice here. Some are saying that the other person, the SUV guy, has a case, and it seems like there have been cases similar to this. Some people are telling me that I am absolutely guilty and should have everything taken from me. Also, I'm not sure who Ayn Rand, legal author, is, and how this affects me. I spoke with a legal hotline service, and they said that they are not sure of the laws, but I need to go get a notarized letter from the SUV guy saying that I won't be sued if I choose to pay. I'm honestly super scared and stressed that my immigration status will be affected, like the guy said. Should I be contacting immigration lawyer too? Sounds like he's bluffing you into paying for damage that you were not responsible for and doing a pretty good job at it. As a driver, he needs to use his own judgment and not substitute it for the judgment of some random stranger walking down the street. My guess is he's going to put in a claim on his insurance and put the money you give him in his pocket. I doubt he will sue you. If he does, you need to answer. If he does sue, I doubt he will win. Until you receive the summons I doubt you will get, you can ignore him. This makes a lot more sense when you put it that way. Everything happened so fast. He was a big guy for you, and was really intimidating, and I just gave him my info without thinking too much. If I do get a summons, will my credit score and stuff be affected? He said outstanding things like that will really mess up my future. Nope, your credit score has nothing to do with the summons. Also, even if you get a summons, that doesn't mean that you will lose. He's just looking for money. Just ignore him 100%, unless you do get a legal summons, then make sure you show up. But until then, don't respond to any calls, texts, and emails. Edit. Also, if you do get a summons, it will most likely be for small claims court. You do not need a lawyer for small claims, and as other posters said, he will be laughed out of court. Seconded, because if you don't show up, you might just immediately lose the case default, regardless of whether you were actually responsible. If he was able to intimidate you once, he'll be able to do it again if you talk to him. If you speak to him, he's going to say all sorts of things that you won't know if they're true or not, and it will cause you a lot of confusion and conflict, and you will do/say more things that will make the situation worse for you. You can't trust anything he says. He is trying to manipulate you into getting money. Block his number, research a couple of lawyers to choose from in case you need them. Also, make sure to save all texts he sends and record any calls that he has with you. It sounds like this could count as borderline harassment at this point, which would negatively impact his credibility if he was dumb enough to try to sue you. Honestly, ignore him. If you actually are sued, speak with an attorney and respond, and ultimately, he is responsible for his own vehicle. He wrecked this vehicle, not you. He's trying to intimidate you because he doesn't want to accept responsibility. Just because someone waves you in doesn't mean they checked the right-of-way is clear for you. A lesson I learned when someone waved me in and I got hit and was responsible for violating the lane's right-of-way. This is practically the textbook example of hearsay as well. I must have heard the "someone waved me into an intersection when I couldn't see the light and it was red" example dozens of times in evidence. I noticed that you were seizing on and responding to the worst case scenario posts on here. Don't ignore the other, very good positive advice given to you. The odds of this person actually suing you are astronomically low. The odds of him successfully suing you are astronomically lower. The odds of him convincing law enforcement to press criminal charges against you are 0. This is a civil matter at best. Finally, in the incredibly unlikely scenario that you are sued, simply call your auto insurance carrier and let them know. Non-legal advice: cease all conduct with this person, do not answer your phone or respond to the letters. If he comes to your home, call 911. Update: I'm a pedestrian who waved in an SUV in a narrow gap, and he got into an accident and he's threatening to sue me. Hey guys, I got into a bit of a situation a few days ago, and I frantically posted about it here yesterday when the other guy contacted me multiple times, threatening to sue me. It was referenced here. I spoke with an advocate in Philadelphia, as well as a lawyer, and a few other people in the legal profession. They have all told me to relax and that a simple thumbs up will do nothing in the courts, and will not affect me in any criminal way, credit score, or immigration status being challenged. The lawyer even said that he'll draft a letter for me on my behalf for free and mail it to that guy to stop contacting me. He even suggested that he'll help me out for free if it goes to court. That's how confident he was that it won't go to court. I don't know if I'm allowed to give him a shout out. I took a few pictures of the intersection and showed it to the lawyer, which I didn't think helped, but the basic gist is that a thumbs up can mean anything, and the burden of proof is on the other guy, not me. He said that I wasn't actively directing traffic, but simply chose to let him know that he was good and has room, and it's up to him to make the final judgment. Personally, many others in the city have done for me when I was parallel parking, and I assumed it was normal here. The big lesson here is that never interfere with a motorist. Despite how aggressive that SUV guy acted, I still feel guilty since 2 people's days were ruined because of my interference. I want to help out, but strongly advised that by people that I spoke with not to, so I won't. Heck, there was even a Redditor who messaged me and offered to pay my legal fees if it came to that. The gesture itself is flipping amazing. Another Redditor offered to meet up with me and act as a friend, since I don't know anyone in Philly, if I chose to speak with the SUV guy, which he suggested not to. And another lawyer, Immigration and Injury on Reddit, that lives in Philly, offered to speak with me. I don't know if I can give them all a shout out either though. The point I want to make with this update is that this is a great effing subreddit with really genuine people that care. Tons of people took their time to personal message me since the thread got locked to tell me that I will be fine and that they will speak with me if I need to speak with someone. Also, Philly is a damn great city, and by no means was I trying to show it in a bad light. Messages from the internet who live here have been pouring in offering to help me out if I need it. I am simply going to stop communicating with this guy. Caught HOA trying to break into my house, now they've issued me with a $1,000 fine, WA. I bought a house 18 months ago, which was a member of the HOA. I did change the front door of the house to something a lot more secure. About a month ago, in the middle of a weekday, I noticed two people trying to open the door with keys which weren't working. I confronted them while my wife called the police, and it became apparent that they were officers of the HOA trying to look for an infringement. There is a section of the CC&Rs that says, the association is entitled to access the homeowner's property with reasonable notice, and also a section that says the homeowner may voluntarily submit the property keys to the association. However, once submitted, the association is not required to return the keys. Submission of a key which does not work may incur a fine determined by the board, which according to them, the keys to my property has been submitted. I'm assuming the previous owner have done so. I have spoken with two board members who said they suspected that the keys they hold for my property may have been fake, and they've authorized their officers to check this out. They say according to them, in this case, as they were searching for an infringement, reasonable notice means no notice, to ensure that I won't have time to replace the locks. And now I've received a $1,000 fine because the keys submitted for my property to the HOA are fake. I have talked to a board member who tells me that their interpretation of the contract is that once a real key is submitted, the key must be kept up to date at all times or a fine is warranted. They also told me not to fight this, as according to the bylaws, the HOA is entitled to recover their legal fees from me in case I bring them to court or they bring me to court. So I'll lose either way because legal fees will end up costing me more than the fine itself. Not sure if it's relevant, but the office of the HOA looks a lot like a leisure room. They have a pool table, a bar with a fancy fridge, and a ton of drinks, a large TV, and couches and stuff like that. And this isn't an amenity that is available for the people living in the neighborhood. This is the relaxation room for the HOA officers and board members who are old, retired people. I definitely felt like this fine is for me to fund whatever they have going on there. Help? I also want to add that this is a house, not a condo or an apartment. If I had a nickel for every time a non-attorney said not to bother because they would win, I could retire. Demand they produce where you, the current homeowner, supplied them keys to the door along with the date. As for a fine to be determined by the board, it has to be founded on some semblance of reasonableness. I can almost guarantee a judge will laugh them out of court if they try and sue/collect on this fine. That sounds promising. They may not be required to return keys. However, they can't fine you for a voluntary action that you yourself did not choose to partake in. If they keep pushing, absolutely approach an attorney. It's worth your time if you plan on living at your residence for the foreseeable future. The only problem is they won't bother to sue if they can't collect. They'll just put a lien on your house and continue fining you until you pay. HOAs are notorious for wielding a tremendous amount of power against homeowners. It may vary by state, but I know that in some states the parties must go through internal dispute resolution/ADR prior to initiating a lawsuit. As for legal fees, I highly doubt the HOA can collect attorney fees whether they win or lose. Much more likely, the prevailing party will be entitled to attorney's fees. Check your CC&Rs for a provision addressing attorney's fees and compare that to RCW 64.38.050, which states attorney's fees go to prevailing party at discretion of the court. While you're at it, just read your CC&Is front to back. It's important now more than ever that you know them. You could try to initiate the internal dispute resolution process to contest the fine and do that yourself and see where that gets you. Check CC&Rs for details on the process. As for your specific violation, it probably would cost you more to hire an attorney and dispute the $1,000 fine in court. If you prevail, the judge might order your attorney's fees covered. You could also check if this is something you could take up yourself in small claims court, which might make some more financial sense. It doesn't sound like the HOA was actually trying to break into your house. They will say they were simply testing the set of keys they had to verify they had the proper set, which doesn't appear to be in violation of the CC&Rs. Your strong point is that the non-working keys were submitted by the previous owner and submission of keys is voluntary. I would argue that you are not liable for the previous owner's failure to provide updated keys, and that once you would change the locks, you are under no obligation to submit a new set of keys because doing so is voluntary under the CC&Rs. Don't forget, if you lose in contesting the violation, you need to contest the amount of the violation. Fines and assessments typically must be reasonable. $1,000 sounds excessive in this case. As for the office turned into leisure room, that is sort of ridiculous. The HOA board has a duty to manage and spend HOA funds in the best interest of the HOA, not for themselves. HOAs are typically required to make financial disclosures to members, so if you have received any such documents, look them over if you haven't already for any money that went toward the leisure room. Also, under RCW 64.38.045, homeowners are entitled to inspect HOA records upon reasonable notice, so give the notice and go find out how much the HOA spent on this room and everything they put into it. If you find out the board of directors is spending quite a bit of homeowners' money on items unrelated to managing and running the HOA, that is something that every single homeowner not on the board of directors will be ticked about. Bring it up at the meeting, use it as leverage in negotiating away your fine, etc. But remember, once you start talking about board members breaching the CC&Rs, fiduciary duties, etc., things can get expensive if you litigate. I would seek a consultation with an experienced HOA attorney if you go this route and try to get other homeowners on board. At the end of the day, HOAs have way too much power. I've seen it and I will never buy into an HOA because of it. Depending on the state, they can even turn unpaid fines and assessments into liens against your home in foreclosure. Litigation can also make it difficult for homeowners to refinance or interested buyers to obtain a mortgage. So, long story short, tread lightly and go for the jugular when you can. If nothing else, rally the other homeowners and run for election to the board of directors so that you can drain the swamp. Once properly drained, throw a rager in the leisure room. Hand deliver invitations to the old offices you replaced. Posted by user Dog Patches. Titled, HOA won't allow open garage door, but I have no other choice. Please help. Hi guys, thanks for taking a moment to read. My condo HOA in Las Vegas does not allow residents to leave an open garage door while not in use. The problem is, my wife and I need to train in there every day. We are Cirque du Soleil acrobats and have both been indefinitely let go until Corona is over. As is such, our gyms at work are gone, public gyms are gone, and we have gone to incredible lengths to procure equipment we can use at home while we wait this out. Also, in Vegas right now, it's over 100 degrees every afternoon, and if we close the door, we would die of heat stroke, as well as not be able to see anything, and we absolutely cannot let off training over this, because it's our only way to maintain during lockdown. Do we have any recourse? Any advice? Thank you, Reddit. Edit, the HOA is requiring I comply or fine me $200 every time it's left open. HOA CC&Rs will likely be the first place to check. You should have gotten a copy when you closed on the condo. What do they say? If the CC&Rs are silent on the issue, you may be able to argue it, but otherwise it could be a hard row to hoe, because the CC&Rs are something you voluntarily agreed to abide by. Is the line from the email regarding in use in the CC&Rs? Not a lawyer, but I would argue that in use commonly means any function typically related to a garage, which for me includes vehicles going in or out, maintaining equipment, and working out. I have my workout stuff in my garage too. But many CC&Rs explicitly prohibit some of these activities, like vehicle maintenance. Yeah, it's in there, so I feel like I'm a bit screwed. But what should I do? I don't know what to do. I'd say it's worth trying to talk to them and ask for special dispensation. Acknowledge you want to maintain the decorum of the neighborhood just like everyone else, and you don't want to have to look at anyone's collection of broken jet skis and Christmas junk either. But that's not what this is. Giving you permission to train is the neighborhood's way of caring for their neighborhood in this difficult situation. Thanks for this. I really like the wording and perspective. I'd actually suggest getting a split AC unit for the garage. You mount the inside part high up on the wall inside, then the outside part is relatively small, and if you're lucky, you can place it somewhere where the HOA allows it, because you've obviously got at least 1 to 2 other ones outside already, since it's Las Vegas. That's sort of a major investment for something that might not be useful in 3 months. Then it's a good thing it'll work next summer too, and the summer after. Lots of people use their garages as a workout space. From a legal perspective, if this is in the CC&Rs or other rules, this is an enforceable rule, as there is no legal protection that says this type of rule is unlawful. The current situation and your profession, generally speaking, do not override a rule of this type, but these rules are enforced by your neighbors and the HOA board, and they can take hardship and pandemic into consideration. The specifics of the bylaw matter. In any case, this type of rule is in place to prevent the garage from being used as a living space, and further to prevent the common area parking from being used. It is possible your use is not a violation of the rule. You could avoid breaking the rule, keep the garage door closed and air condition the space, or work out inside your home. You could ask for permission from the board. You could ask your neighbors not to report your garage door for being open. You could get enough homeowners together and change the rule. If you have received a fine already, you should ask for a hearing and make your case there. Can't you just incorporate 2 foot of your driveway to your workout routine? Then you would be continually entering and exiting your garage. It's not like you're putting crap on display, you are actively using the garage. If you take numerous items out to the trash, you aren't expected to close the garage behind you, so why is this different if your workout takes you outside and back? If you're in their training, wouldn't it be in use? It says in their email, in use, entering or leaving the garage. Heck, I don't know about this one. What would you guys do in a dispute like this? It's a lot of good advice here. Posted by user CMHSGrado2, titled, Right Number, Wrong Street. First time posting. About 5 years ago, at an old place, we had an HOA, our third in the time we lived there. That was sending us letters that we need to clear a patch of grass that had to be clear as HOA rule. So I rented a weed whacker and cleared out the overgrown weeds that grew in the years we were there. Only other grass was fake carpet grass that inside that yard. Thought that was the end of it. Weeds kept growing and we cleaned it off. Finances got hard and a landlord took over and let us stay as long as we wanted. He started getting letters about clearing out the growth of the same patch. Even hired a landscaper to get the roots out of it. Still kept getting letters, and we got into fights about the patch not being cleaned out of the small amount of weeds we still gathered on monthly basis. Finally called the HOA about the proof, and they sent a picture of the growth as our patch was clear. Got the picture sent to us of a completely other townhome, but had a giant tree about 10 feet covering that front window. Told the HOA that we don't have a giant bush covering. Drove around and found the matching bush from the picture. Same address number, but the correct address was for the east side street. We lived on the west side street of the complex. This was after 3 years of arguments between the HOA, the landlord, and my family about a unit that wasn't even occupied by us. Could you sue the individual who took the picture and send the notice for gross negligence? Damages would be the money you spent fixing a non-existent problem due to their incompetence. We asked the HOA to take the picture as proof. It is nice that you actually found an explanation for the HOA's screwery, other than they were trying to siphon money out of my pocket. Sending the bill to East Weed Lane instead of West Weed Lane is more understandable, even though it's incompetent. HOAs do have a responsibility to be domain-specific experts on these sort of matters. They also have an obligation to clarify the specifics of a violation. Moral, even where it's not legal. Posted by user Al Spank, titled Mutiny. I need some advice. We have a small association with 5 board members. They are members that are only part-time homeowners, good old boys club. They have screwed us over on a couple issues, and are now trying to do a large special assessment, even though we have an almost $200,000 surplus. Their reason is they want to beautify the hot tub area. Eye roll. The hot tub is perfectly fine, and they all want 26 units to chip in another 8K. They can't do any construction due to COVID anyway. To the point, I believe that a majority of homeowners are not happy with the board. Is there a way in the state of Colorado to get a majority of homeowners band together and get not only this special assessment thrown out, but also start removing board members? How about firing the current property management company that we hired and are paying for? Thanks for any advice. Look through your association's CC&Rs and bylaws. If the project is not a repair but is a capital improvement, then it probably needs to be voted on by all homeowners. Depends on what your docs say. For example, if under $5,000, then no vote. If $5,000 to $20,000, then X percentage must approve. If over $20,000, then Y percentage must approve. Your docs would also be the place to see if there are any terms for special elections or removal of board members. But make sure there are other homeowners that are willing to be board members. You can't just not have board members. What is the problem with the property manager? I thought your problem was with the board, not the property manager. If you don't have a property manager, then who will manage the funds, accounts, bills, taxes, insurance contracts, etc.? And what is the $200,000 surplus? Surplus is only if you have more money than what your reserve count would be when funded at 100%. That's good advice, thank you. It's $200,000, so I will do some research into the approval. We were never given a vote, just a notice saying the board was voting on it. I do think an issue we have is that it is a tourist mountain town, so many of the other homeowners are part-time owners and don't pay a lot of attention to what the board is doing. I think there are a few owners who would consider HOA positions that I think would be better suited for the spots. The property manager is the icing on the cake. She is overzealous, rude, and harassing. However, it's the board we have the major issues with. She can be removed if the board changes. Our personal issue that we're having with the board is we had a garage conversion done with the owner before we bought the place a few years ago. The board tried to come after us recently for the conversion, saying we have to pay for the permits and work to cover it back to the original building plan. They lost that fight due to the statute of limitations, so decided to tell on us to the town. Now the town is coming after us, so we are having to get our title company, lawyers, etc. involved, all during a pandemic, jobs being on hold, and a newborn coming soon. $200K special assessment, we already have $200K surplus currently. They just want to do some unnecessary projects and charge us an extra $8,000 each condo. Also, surplus now does not mean a project is funded. That money may be for work complete and not billed, or for utilities, held until a reserve fund study shows a massive top-up is required, or maybe it's a contingency fund for odd events, which could happen during a huge frickin' pandemic. The surplus is after the budget was balanced, all expenses were covered for each year. They want us to look like we have a healthy amount for buyers. It's asinine to think they know enough that a surplus looks good, but don't know that a special assessment on cosmetic upgrades looks bad. But then again, we're in Screw HOA. Posted by user JCR5431, titled, Can I Sue My HOA? I live just outside Portland, Oregon in the US. I bought my condo a few years ago, and I live on the ground floor with a neighbor above me. The HOA has very strict bylaws and love to issue fines for violations. One of the rules in the bylaws were that upstairs units aren't allowed to have any type of flooring other than carpet. My upstairs neighbor installed it anyway, and I hear everything. They can't sneeze or have sex without me knowing about it. I complained to the HOA, and instead of fixing the issue, they approved a one-off situation where they had to soundproof the floors with an extra layer under the hardwood to cushion sound. It has only made things worse. I feel like I'm living under the cast of Stomp 24/7. They walk and run around their place constantly, and sometimes they are so loud it shakes my walls. I am no longer comfortable in my own home, and I have no idea how I will be able to sell my place with those two upstairs. Is there anything legally I can do about this situation? I am planning on selling soon and I am freaking out. Have you read your bylaws about how to escalate the complaint? There are often internal mechanisms that must be done first. Also, if they were shaking the walls in your apartment, installing carpet is unlikely going to stop your issues. There may be more to the problem. I will have to reread them. I don't recall anything about escalating issues. I have complained to them about noise prior to them approving the floors, and they did nothing. Mind if I inquire about the type of flooring your upstairs neighbors had installed? Obviously, hardwood and natural stone are going to have two different effects on the situation. Natural stone is heavier and would cause more shaking below, but would bounce the sounds of personal affairs away from a unit a little better. Hardwood is lighter but less muffled. If you're receiving the worst of both worlds, there may be a structural concern with the entire building at this point. However, I will side with the commenter, as you will need to be fully aware of the bylaws. Unfortunately, your upstairs neighbors have also paid for their home and also retain a more permanent interest in their dwelling. Think of your downstairs neighbors wanting to sue the HOA due to you living normally. Since you haven't described how the HOA approved the one-off, it's not possible to give you advice about whether it was legal. If you are considering selling, consult a realtor. All may not be lost. You will need to disclose that there is noise from the upstairs neighbors, but this is common for such units and was likely reflected in the price you paid for the unit. I get that you find it unlivable, but other people might. Lots of people live downstairs from hardwood floors. Some think it's fine, others can't stand it. For you, the noise is going to be 10 times more aggravating because it reminds you that they broke the rules and you remember when it was quieter. But you only need to find one noise-tolerant person to buy it. We have a monthly newsletter, and they wrote in there that they approved one upstairs unit to have hardwood floors, and a week later I heard them doing the install upstairs. They never consulted me first, which I am not sure they are required to do, but it would have been nice to have an opinion on something that directly affects me. One thing to be aware of is that if you sue the HOA, you create a situation where banks may not provide financing on any units in the HOA until the suit is complete. This can drive your home values down and have other unintended consequences. I'm not a lawyer, but work for a bank and have had to sue an HOA. Well, this is all really good advice. I hope it helped you guys with your HOA disputes. Posted by user altaccount122333, titled HOA Fighting Me for Weeds When There Aren't Any Weeds. In late January, my wife and I were preparing to get married and let our front yard get a little out of hand. Lots of weeds. On Super Bowl Sunday, we took the time to clean up the yard and get things in order. We received a letter that week telling us that they were fining us for the weeds. It sucked, but was understandable, as we had cleaned up the weeds, paid the fine, so we figured that we were all good. Since then, we have been on top of our yard and kept it in great order. Yet every month we get another nasty gram telling us that they are going to fine us again for the weeds when there are none. Last month, they even sent us the same picture from January, saying that if we don't resolve the issue, they will raise the fine. I have tried to call the HOA, but they are all working from home, and don't have the ability to answer the phone. I've emailed them without response. Also, it looks like board meetings are now being placed on hold due to COVID-19. Part of me wants to just give up on keeping the yard in order. I mean, if they're going to fine me for it anyway, what's the point of keeping up with it? We have only lived with an HOA for the past year and a half. I expect some blood-sucking, but this is getting ridiculous. Has anyone else experienced a similar issue of being fined for something that just doesn't exist? If so, are there any suggestions on how to handle this? Send a registered letter back to them explaining that you cleaned up your land on this date and that the photo is a duplicate. Then, every month, draw a line with spray paint on your lawn like a counter and take a photo of it on the beginning and end of each month. If the photo they send you does not have the markings, you know it's not real. I think a registered letter is the key here. I sent an email basically saying that, but it went into the abyss. Good idea on the counter. I think I will implement something like that. Be sure to include information about the email, such as date and time it was sent. I would also include a hard copy of the email as an enclosure with the letter. Every time you have to contact them about the issue, including what you had done previously, keep following up via emails or letters until this is resolved. You need to create a paper trail. Mail them a date-stamped photo of your yard with a note saying the weeds have been taken care of for a long time, and you don't appreciate being threatened over an issue that doesn't exist. Make a stink about it on your next door, and see if other people in your neighborhood have similar issues with the association. I honestly don't see the appeal of these neighborhoods. After you pay all the dues and fines over the years, it eats up any additional money you supposedly get from a slightly higher market value. I definitely understand your logic regarding dues and fines and agree. We just fell in love with the house and thought we could deal with it, starting to learn otherwise. I'm so sorry that happened to you. I moved to my current city from one that I didn't have HOAs, and they weren't really avoidable where I live now. But if I'd had known what a pain in the ass they are, or really understood what they are, I would have chosen another city altogether. Everything was fine until recently, and now it's all getting out of hand. I love my home, but if I ever do move, it's going to be to a different city where I can avoid this scourge upon humanity, and it will most likely be because of the HOA here becoming too unbearable. Jesus. Seattle Park nails the spite. Poison 1 tree, we'll plant 4 in its place. Notice, vandalism of vegetation/tree removal. In April 2019, the Seattle Parks and Recreation SPR was made aware that an unknown person or persons fatality damaged 2 Douglas fir trees at the southeast corner of Magnolia Park. Herbicide was poured into holes that were drilled into the trunks of each tree. There were scars on the trunk of each tree, indicating that this was not the first time that these trees had been vandalized. SPR has identified the herbicide that was used, and we believe that there is no risk to adjacent trees or people using the park. 1 tree was removed, and 4 trees were planted in its place. At this time, SPR does not know who committed this crime. If you have any information regarding this act, please contact SPR Property and Acquisition staff at 206-684-4860. Now, if you guys are unaware of what this subreddit is, the auto moderator gives a good idea of it. This subreddit is for tree law enthusiasts who enjoy browsing a list of tree law stories from other locations, subreddits, news articles, etc., and is not the best place to receive answers to questions about what the law is. There are better places for that. If you're attempting to understand more about tree laws in regards to particular situations, please redirect your questions to r/LegalAdvice for the US or the appropriate legal advice subreddit for the location, and then feel free to cross-post that thread here for posterity. So yeah, that gives you a good idea of what this is all about, guys. In regards to the post, Rosie for the win says, "What's most interesting to me regarding this photo is that despite being laminated and attached to a post, this sign was clearly torn in half and rehung again with packing tape. Neighborhood drama? Not to mention the malicious and pre-planned described act of killing several trees in such a particular way. I wonder the motivation, like, was it bordering their property? Grievance with the Parks Department? I need details, people." The area this was in is roughly here. All the houses look southwest/west onto Puget Sound. My guess is this was view-related, and it wouldn't surprise me in that neighborhood. Looking on the street view, you can pretty much tell which houses did it. That's a big ol' to me, not gonna lie. Several years ago, we were renting a very modest mid-century house that was uphill from Lake Washington shoreline by about 3 lots and about 50 to 70 feet vertically. Across the street and further uphill was a recently built house that we dubbed the Fortress. Unconfirmed word was that it was owned by a Taiwanese millionaire who bought it and only visited for a month or 2 a year. We rarely saw any activity there. The only interaction we had with the owners/occupants the entire time we lived there was a single encounter with an older Asian lady who kept badgering us, asking us over and over, how much to cut down trees? The trees in question were a row of slim tall trees on our side of the road. Over the years, other big trees in the area, not far from the water, had rings of bark stripped from around their bases and in the middle of the night in order to kill them. Enough people, it seems, will pull crap like that and kill trees just to improve their water views if they think they can get away with it. I'm really happy to see the Parks Department not stand still for this. Our next post is by user Snowboarder, with this picture saying, "My neighbor went overboard." Oh my god, what has happened to this beautiful tree? The guy that owns the home next to me said he was going to trim some branches from my fully grown Japanese plum tree because it was touching his roof, and I came home to this. I'm in shock and don't know what to do other than try to not strangle the guy. Oof, get an arborist and a lawyer, and some nice thick gloves so you don't get strangle blisters, or leave DNA evidence. Make sure they don't fit and make a big deal about it at the trial. Ah yes, the old OJ tactic. I think he is only allowed to trim the portions that cross over into his property, anything passing through a vertical plane extending upwards from the property line. If he trims anything on your property, or trims anything anywhere that causes harm to the overall health of the tree, I'm pretty sure that's a big no-no. That would be the case had OP not told him it was okay for him to cut branches. He's going to argue that OP gave him permission, and that he is taking more off than OP desires was just a miscommunication. Posted by user Birdabad, titled, "Builders left a huge pile of trees/vegetation on our lot and is saying that they will not remove them. Located in Georgia, are they responsible for clearing this?" That's quite a lot of stuff, goddamn. I am not a lawyer, are they your builders? Yes, we're set to close this Friday, and we just found this in the very back corner of our lot yesterday. It was not disclosed. I would check any contracts you signed. I don't think it's specified in the contract, but I'll look over it. Thank you. Most contracts do have some information in them about the removal of construction debris. The most important thing, refuse to close on the house. That is the only power you have. Once you've closed, they can peace out. If you refuse to close until it is fixed, it will get fixed. Yup, this is exactly why you do walkthrough inspections the day before close. I think it's pretty typical for the finest brush and sticks to be left behind absent an agreement. I live on a freshly cleared lot for 3 years, and still clearing away wood the builders left. Oof. I am not a lawyer, but as was said above, don't close on the work. If you have, then it will be a lot harder. You may have to go to court. Another option, if you have the experience and room to do it, is just to burn it. You will have to file for a burn permit, and it might scar the area for a couple of months, but it would be a way to deal with it. Make sure you have a water source on hand and keep things small. Abide by any other local laws. Thanks. The problem is it's far from any water source, and we can't burn anything until September due to a yearly burn ban in our area. I recently had a similar experience. If you buy the land, then waste is likely your responsibility. But if they dumped illegally, without the permission of the previous landowners, then they are responsible both in civil and criminal courts. The legal battle will be a hassle. Even if you win the case, you will lose. I suggest that A, you write a letter threatening legal action, but then B, when the builder does not respond, just burn the pile and be done with it. Maybe just don't buy the house from those a-holes. Yeah. We're hoping we can talk them into moving it and have a burn ban until September, and it's the waste from 4 lots, not just ours. Thanks for the advice. Professional forester and consulting arborist here. If you can get the builder to remove it, cool. If not, don't go through all this legal bullcrap for what amounts to up to $500 worth of cleanup. Call a tree care company and it'll be gone in 2 hours of chipping. Of course, all this depends on access. If it's easily accessible, it's easily fixed. If a truck and chipper can't access it and it's a long drag to the closest access, it'll be more difficult to clean up. But realistically, this is a small pile of brush that you're looking to turn into a mountain of trouble and expenses once lawyers get involved. Thanks for this. We just had no idea the cost and hassle involved in this, which was worrying. We don't have vehicle access through our lot, but there is one through our neighbor's lot, so we're hoping they'll allow us to remove it this way. There's a dirt path through their lot that was used to dump this, so it probably won't be a huge deal. Also, if you wish to do any veggie and fruit growing in years to come, that pile of wood chips would be very useful to have. Oh my god, it's from a local, I have to help this man's. Posted by Dak Butt, titled, "Neighbor has couscous, queen palm, that hangs over our fence. Do I have any legal right to request its removal? Hi there, I'm an Ippy, Queensland, Australia, and our neighbours have a cocos palm that is right on our boundary. I know I said cuckoos, I was just playing around. It drops so many fruit or seeds on our lawn, but for them it's in a garden. The tree is far too tall for me to climb in any way to cut down the fruits and flower clusters. In Australia, the cocos palm is invasive, but it's not specifically targeted in legislation to be removed. Our dogs eat the fruit, there's hundreds, and apparently it can be mildly poisonous to dogs. Is there anything I can do? Thanks heaps. Edited, I have researched more on the toxicity to dogs, and it seems they're fine. It was just one website that suggested they mightn't be. However, there are many more reports of dogs eating the seeds and having blockages. And also, more seriously, the cocos palm is very damaging to the native bat, the flying fox. Oh, I didn't know that. And our area/suburb is very well known to have a colony of flying foxes. I have a ficus religosa on my property that has hundreds and hundreds of flying foxes. The more you know. I used to have one of those growing in my backyard, and actually the property that I'm living in back home has a whole bunch of cocos palms on it, like everywhere. They're all over the suburb. That's insane. Didn't know, I thought, because I see bats eating them all the time, I thought it was good for the bats. Anyway, so looking at the public data for Queensland, I got to here, which is just in Queensland agricultural side of the government section. I went to the resolving disputes section, and then what to do if your neighbour's tree is affecting you. It seems to cover your concern from what I've read, and it outlines the different types of steps you can take. Of course, the best course of action is to talk it out with your neighbour. I get the feeling you haven't. Before you bring down the hammer of the law on them, you should go over and talk to them about your concern, that it could make your dog sick, primarily, and that the fruits are making a mess of your yard. The queen palm is technically listed as invasive, sure, but it's an internationally popular ornamental tree. This is probably why it's not policed. It's not by dint of species and nuisance, like kudzu or bamboo. This particular tree is just a little messy. So after you talk to your neighbour about your concerns, try to work out how to abate the problem. Since you're worried for your dog and yard, and they probably don't want the tree to be killed by poor trimming, it's in both of your interests to get a professional out to take care of it, especially since it's too high for you to deal with yourself. Of course, if they cuss at you then slam the door, then you might want to look down at the list at other options. Not knowing your neighbours, they're probably reasonable, and you should remember to be reasonable too, and not just throw the problem in their laps. Thank you, kind stranger. Your words are helpful and wise. I'm dreading the conversation a little bit. It would be easier in the short term to just be passive-aggressive and throw the seeds back into their lawn, but I know that's unhelpful and immature. Still very tempting though. But I'll be a big boy and go and have the adult conversation with them. That's a good idea. I hate queen palms. However, despite owning more of these palms than I care to count, I've never ever had any of the dogs that I've lived with here eat the fruit and get sick. Also, squirrels eat that fruit and do just fine. Just because you do not like having these palms hanging over your fence doesn't mean that they have to cease to exist. My suggestion, unpopular as it's going to be on this thread, is that you relax. It's okay if there are palms you don't like that you have to look at, and if you're really worried about the fruit, pick it up. Yeah, I really probably do need to chill about it. It's become a thing in my head. Perhaps my neighbours can just get an arborist to cut off the 2 seed clusters. Well, I'm glad my ippy brother was able to solve this one. Good on you, Dak, but Godspeed to ya. Posted by user SadTrees10, titled, Help evaluating if there is anything more I should be doing in a tree trespass dispute. Here is a set of events that happened over the last 2 to 3 years, and I request your guidance. Episode 1. 2.5 years ago, during a severe storm with winds, top of a tree on our property broke off and landed on a neighbour's backyard. We had previously done trimming of the tree just months ago, and the arborist said it was in good shape and we need to check back in 3 years. We gave our insurance details and our insurance company offered to clean up the branch, given that we had recently done the inspection and we could not have foreseen this. Neighbours rejected the offer, wanted the tree cut, and all the other 7 trees cut in our backyard. They threatened lawsuits, and them churning through 6 lawyers and months of back and forth later, they go silent. No lawsuit filed. Our insurance company provided lawyer representation for us. We did more arborist inspections, and they said the trees do not need to be removed. Oh, and the fallen branch is still there. Episode 2. Last year, while walking in the yard, I noticed a strong diesel smell, and upon closer inspection, it was apparent that someone had poured diesel on the roots of the concerned trees, and more trees, with salt in a trench around the tree. I learned from the internet this is a thing to kill trees. Why would they do this to kill beautiful trees? We reported them to the police. We have a lawsuit on them as a result. They made it incredibly hard to serve them. Finally, they accepted it and immediately filed the lawsuit on us for episode 1. They do not have a lawyer for episode 1, they are representing themselves. Meanwhile, they are not responsive on any communication, and it is incredibly hard to work with them. So we went for summary judgment for the lawsuit they brought on us, but they used tactics and got it postponed twice for another 3 months. Judge noticed that, and he was not happy about them dragging it. Both my lawyers are excellent. They are very good at explaining things to me. I'm very worried about the neighbor. Could you please help me with the following? A. What is the neighbor's incentive to keep postponing and not being responsive? B. Am I missing something else that I should do in my best interest? C. If the court says we have to remove 7 to 8 trees, who would have to bear the cost? We love the trees and we hate to lose them. This is so unfair that they/someone poison the trees and we have to lose the trees and pay for it to get removed. I know life can be unfair, but still. I omitted more crazy stuff, including them bad-mouthing us to our neighbors, HOA, TV station, da-da-da-da-da. Thank you so much. So Driving the Skeleton, very wise man, says, I think the reason they're dragging it out is twofold. They are trying to wear you down so you'll just give up, and or they're trying to get a court date that you can't and won't show up to, in which case they'll win by default. It sounds like you're doing everything in your power, just make sure you know your dates and deadlines for court stuff. Your lawyers will likely be very good about that, so you shouldn't stress too much about it. Your last question will likely be determined by the courts. Good luck with your case, and I'm sorry to hear about your trees. I hope you're able to plant 2 trees for each one you've lost. Obligatory, I'm not a lawyer. Not a lawyer, but they may be dragging it out in the hopes that you'll give up due to spending money in lawyer fees. As a side note, I would recommend putting up some security cameras and maybe a motion sensor light in case they try to trespassing to cause any more damage. Good luck. I can't help you with question A, but this might help with B and C. I am not a lawyer. You had no responsibility for a tree part breaking off of a healthy tree and landing in their yard. That's considered an act of God legally, and for insurance purposes, so you had no liability. I'm surprised your insurance company played ball with them at all. By the same token, if their tree's branch had landed in your yard, you'd have no legal expectation of assistance for any portion inside your property line. It's yours now, and you own it. When you buy a house, you buy your neighbor's trees to an extent as well, for better or for worse. Make sure you have plenty of video evidence, photos, and whatnot for the looming destruction of your trees. Get a certified arborist who's trained in evaluation to estimate the replacement costs of your trees in their present state of maturity, because that's what your neighbors will owe you. That can easily go into 6 figures depending on size and maturity, location, and other factors. In some states, treble damages may even apply, even without proving malicious intent. Yes, makes sense. I agree that we and our insurance has worked with goodwill intent to help them out. However, on the other case, without a video proof, how likely is it to convince the court that they are the liable party here? Depends on you and the fight within you. This is a near slam dunk case legally, and is only yours to lose. Few have video proof of something like this, but they win if their story is compelling and tight in the courtroom. Use what you got. Posted by user, Bullis is my reason too. Titled, Neighbor's tree is growing into my fence, looking to replace my fence. What are my options? And here's the picture. Oh my god, that tree is gonna fall over, it looks like. What the hell? And look at the state of that fence. Oh my god. I'd like to see a photo of the whole tree. Hard to tell if that's a recent or historic lien. What I see from this is concerning. Certified arborist and risk assessor. I'd suggest getting a consult from a local arborist at minimum. Same here. The branch structure doesn't seem to show it grew this way. A few branches seem to have changed the growth direction, and I'm leaning towards this happened a few years ago. Hard to say though without getting a good real look. Edit, I think I was mixing a few branches up from behind the tree, and I'm not sure about the previous comment. That being said, the branch structure is still off, I just can't tell if any of the newish growth has changed direction or not. Correct me if I'm wrong, but isn't that tree falling? I see a main apice, all diagonal. Maybe call an arborist and give you better advice? Agreed. Trees do not grow naturally with their apex and primary trunk at an angle. Sure, some trees may split down low and grow in a V formation, but this looks like a single trunk tree that is falling. OP may want to work with his neighbor to have the whole thing removed. One heavy snowfall and that tree is coming down. That tree does not look structurally sound. It's teetering into your property. Did you discuss anything with the neighbor yet? No, the house is currently on the market. It was a foreclosure that some investor bought up and flipped. Oof, that's basically all the advice. Just get that tree taken down, get an arborist, get out of there. Posted by user skr4. Titled, Trees are basically uprooted and falling, neighbor tree. It's falling over our property line and might take down a net we built. Oh my god, what? Oh, that's so sad. Why did the neighbors let this happen to these trees? That looks like land erosion, doesn't it? Like that land is just falling down. Obvious question, but have you talked to your neighbor? Yeah, just told me it's on the list, lol. They said they just need to cut them out and hopefully they don't fall anymore. We had a pretty bad storm recently, which may have uprooted them even more than they were. Send them a certified letter about your concerns. This way they can't argue that they had no idea. Some people also send a copy to themselves as proof. Next, when the trees fall or start to damage your fence, you call their property insurance company and file a claim. The trees on their property are their responsibility. If it can be shown that the trees were unhealthy or not being taken care of properly, that is a mark against the neighbors. Source, live in Florida and had a healthy tree fall on a fence the neighbor put up to keep his cattle off our property due to a hurricane. He didn't want to fix it until after the letter was sent showing the tree was healthy when the storm blew it over, as an act of God. Not the greatest picture, but we are worried about being liable to deal with these once they fully come down and destroy the fences and our net. Wondering if we don't take action right now, or they don't deal with it, how can we act? Pototo72 puts it pretty well. This is more of a fan club. Head over to r/legaladvice. Damn it, it's a good fan club. We're strong in r/tree law. This tree looks pretty unhealthy. If your neighbor doesn't remove it and it falls over on your property, your neighbor could be liable. I really need a better picture to fully understand the problem. An MS Paint drawing would genuinely really help. What is that? Oh my god. Well, no offense, but I'm even more confused now. So if I understand this masterpiece, is it the roots that are going to disrupt your property, or whose tree is it? Is it their tree falling onto their property, but the roots coming up disrupting your property? He says the tree is on their property, and falling from theirs onto mine. Taken on their property as we kind of share the front lawn space right there. I think I'm done with this post, man. Ah, hell yeah, an r/entitled people post. By user French Polka Dot. Titled, Entitled neighbor sneaks onto our property and cuts down the old oak tree to have a better view. I can't get over that picture. It's so bad. Oh my god. Oh, sorry. So this is a story of... Oh, okay, I just cut that out. I've calmed down now. So this is a story of when I was a child and was living at my parents' house. For context, my parents and I live in France, and they bought some land 25 years ago. Now, the land plot was located on a hill and had an incredible view of Mont Blanc. At that time, we just had one neighbor, and our house was quickly constructed. A few years later, the area became quite popular, and all the available plots in the hill were bought/constructed. Now, when I was about 14 or 15 years old, we already knew that one of our neighbors, entitled neighbor, was a piece of work. I only remember that she was super weird. like walking naked in their driveway that was right below my window, but can't recall much more. One day, entitled neighbor comes by our house and asks to talk to my dad. She says that she is hiring a gardener to clean up the bushes on her side of her property, and is asking nicely if said gardener can trim some of our tree branches that are crossing to her side. No problem, as in France, it's expected to cut the branches that are bridging into your neighbor's property side. My dad offers to do it himself, but entitled neighbor insists that it's best if her gardener does it. Entitled neighbor and dad agree. A few days or weeks later, we go on vacation and forget a little about the whole ordeal. Well, you can already guess that we came home to a big surprise. Turns out that trimming does not mean the same thing to some entitled neighbors out there. A whole tree was missing, like a big whole tree. We decided to keep our calm and go to entitled neighbor's house to hear what she has to say for her defense. Guys, this entitled neighbor told her gardener to cut down our old oak tree so that she can have a better view on the Mont Blanc. She even acts shocked to learn that was an oak tree and tried to explain to us that the gardener said it was just a scrub/random trees. We were furious at the audacity of the woman. Turns out that entitled neighbor thought she was entitled to have a view on the Mont Blanc as, since she moved in a few years after us, she never got a chance to see the landscape due to our trees. Like, entitled neighbor bought her house knowing it didn't have a view of the landscape, but thought after 10 years of having our trees, it's time to cut them down. We tried to hear some more from entitled neighbor's gardener, because the guy obviously went on our property when we weren't there and cut down an old tree without our consent. He said that entitled neighbor told him we've been neighbors for so long and that she had our consent to take it down. I wish I could say we have some sort of revenge or even got it replaced, but to buy a full-size tree is really expensive. The best we accomplished was to have her give us a bit of money to buy another tree. I'd like to remember that even though we didn't have enough to buy another oak, we bought a tree with even more branches. Edit. Thanks a lot for the reply, guys. For those of you asking and wondering, a few years after this incident, my parents got divorced, we moved out of the house and sold it. At the time, we thought it was more valuable to try to keep a decent relationship with our neighbors instead of trying to sue the entitled neighbor. To be fair, it was the only time entitled neighbor crossed the border, otherwise she was just a bit crazy, but nothing too serious. Alright, I've finally managed to stop laughing at that stupid tree law MS Paint. I didn't expect to find a gem, but oh my god, you do some searching, you don't stop laughing for 10 minutes. I hope you guys enjoyed this one today. I'm gonna throw you back to outro, Marcus. Hope you guys really enjoyed that one. I couldn't stop laughing, I'm not gonna lie. I know that some of these ones didn't have good endings, that's for sure, but what can you do? Alright guys, that's all for today's episode. I hope you enjoyed it. If you did, be sure to tell me what you thought about it down in the comments down below. If you're new to the channel also, don't forget to subscribe. It would really help out with my channel growth. And also, a huge shout out to my channel patrons and members. I just love you guys and thank you for supporting me on this journey. If you guys are new to the channel and you'd like to support me, links are down below for the Patreon, or you can click the join button next to subscribe if you'd like to become a channel member. Alright guys, that's all for today's episode. I hope you enjoyed it. I hope you have a good day, night, sleep, whatever you're up to, and I'll see you in the next episode. Bye.